business judgment on gossip and nothing more, you're one lousy businessman, if you excuse the expression. And you're too good a businessman to have operated just on gossip. So obviously you guys knew something pretty significant. You knew something pretty specific. And you're sitting here before a Senate committee under oath telling me you didn't know anything specific about the actions of your competitors. And I think that's just a further evidence of the reprehensible conduct on the part of you and your company. I appreciate your staying your answers. And I, quite frankly, don't like it a whole lot. So I just thought I'd touch the subject and call the chair.
Thank you very much.
Thank you. Thank you very much.
Thank you very much.
Only one.
Hank said he was sick to his stomach and he didn't want to know what I was.
And the last paragraph, and page 150, states that, quote, "This contingency fund has been used by the consultant for under-the-table compensation to Saudi officials to get the contract signed." And that, of course, is why you paid it, wasn't it, to get the contract signed?
That in cases covered some of it, yes, sir.
Just to read the whole statement from the document into the record, the increase in isn't that an extraordinarily loose control of such large sums of money?
It could be interpreted that way, but that's a fact.
Sale of military weapons. And the money is coming back and being invested in this country, so that as a result of these extortionate practices, American companies are really financing the purchases in the United States of Khashoggi and his associates. And that's one of the ways that these...
Now, we've kind of tied the hands of our salesmen a bit, and I don't know what's going to happen unless we get on with our legislation and our regulation, and everybody abides by the same rules. Now, and I think the international side of it, I think we ought to work very hard on that, and of course we're not able to do that. I think that's going to have to come from our government to government. But you can rest assured that we are already living by this new policy, which is a tough policy, and it may be tougher than the laws you pass, and it may be tougher than the SEC regulations.
Well, the SEC doesn't have anything to do with anything except disclosure.
Well, yes.
I mean, the SEC is not a policeman in any sense of trying to establish and enforce moral conduct or proper business ethics as far as that goes, but just disclosure of what happens. Again, I don't know. The record is replete with this kind of thing, and the amounts are involved, and this chairman has indicated they're over $100 million. It's an incredible situation. I don't know. There's very much purpose as far as I'm concerned in going into this in more specific detail. All these things happen. They involve dubious tax deductions for purposes which are probably illegal, and they do involve the corruption of people who are at a position of trust in order to get them to abuse their trust for which they should show toward their own governments, and prefer for, because I'm not, but there was a fellow who had been convicted of cheating some of his clients. I don't know whether he was a broker or what he was. And he was up for a sentence, and before he was sentenced, the judge asked him if there's anything he'd like to say. And he said to the man, he said, "Aren't you ashamed to cheat all these nice people who trusted you?" And the man said, "Well, Judge, whom can you cheat?" And that's the basic reason, I think, for being disgusted with a kind of operation that involves the subversion of people who necessarily have to put their trust in you. That's the whole thing.
Mr. Chairman,
Three questions.
Yes, certainly. Then I have two other matters I'd like to pursue with you, Mr. Houghton, and then I want to turn to Senator Biden. Senator Biden is a member of the full committee, and he's most welcome this morning.
Following up on Senator Case's question, Mr. Houghton, I detected a sense of hesitancy in your voice and in your answer. Any way to sew up this business that Lockheed had become so adept at this that it was far more experienced and competitive with respect to other American corporations that you were competing against, and that you could outdo them, that you knew avenues and used procedures and methods that could sew that business up for Lockheed and keep you going.
May I speak to the allegation in the Northrop testimony in the documents?
Yes, of course.
Because I asked our attorneys to try to find out what they were talking about. And it turned out that they used one of our contracts that we had with Dutch Commerce, a perfectly reputable firm in West Germany, headed up by Dr. Frank Fowler. And we had, it had 4.5 pages, and they copied 4 of the pages identical, paragraph numbers and all. And then the part that they didn't copy had to do with what it was all about, how much commissions and so forth. To say that we've had a company like the EDC Corporation that Northrop disclosed in their Ernest report and then their director's report is not correct. We have not had a comparable corporation to that. And why they said they wanted to copy us, I don't know. But you can rest assured that they are skillful people to do the amount of selling that they do. And I don't ordinarily as a government say that I ought to use any particular sales practice in order to export, in order to get business abroad. And while I'm speaking, Senator Percy, if I may, I think I ought to make one thing clear. When I refused to let the fellows put another $100,000 on the Jetstar, the 4th Jetstar of Indonesia, that airplane already had some commissions in it, and I thought it was enough. I don't want to lead you or the subcommittee or anybody as an indication that I was through being a party to paying commissions, some of which might go to government officials back at that time period. I don't want to fly under false colors, and I want to, I appreciate you talking about that particular one, but I don't want to indicate that, that some of these other things that went on subsequent to that time that I didn't know about it, because I didn't know every detail, but I knew many of them, and I could have known them all, so I want to make my position clear, so it doesn't seem like I'm not.
Well, I think.
And we've won some and we've lost some. And we've lost some to our fellow competitors in this country, and we've lost some to foreign competitors. But to answer your question, yes, we have.
To your knowledge, have you ever lost business in the L-1011 because some other competitor was willing to pay more in a commission, bribe, kickback, whatever you might want to call it, than you were?
I couldn't prove that, and I think all of us in this country have lost some because of the assistance given to our competitors abroad by their governments in the sale of other services and goods and military products where we are unable to sell certain countries.
Mr. Chairman, thank you very much indeed, and thank you again for your candor.
A member of the staff has pointed out to me that Saudi Arabia has 7 million people, and we now have testimony before us that Lockheed.
We're competing not with necessarily another airplane just like ours, but we're competing for the sales dollars that would be spent on something else.
Such as?
Such as fighter airplanes, such as tanks, such as guns,
Well, that's an extraordinary argument, such as Kellogg cornflakes? I mean, what you're really saying there is that if we don't get their dollars, they might spend it for something unrelated to aircraft.
No,
It's not the competition for aircraft that's involved, because you've conceded that this aircraft, either they want it or they don't. But simply because if you don't pay commissions, they might buy food or they might buy something unrelated to aircraft. You see, this is where the whole practice becomes so venal. If you base your sales on payoffs to government officials and make them rich, then you force these governments in the direction of military sales purchases, when other purchases might be far more beneficial to them and to their people. You can't come here and argue that even though the C-130 had no competition, they might have bought something else if you didn't engage in a payoff.
Chairman, I reminded the comparison with Cook County, which will be one solid sheet of concrete if we keep paving it over this way. And I suspect there's a relationship between the desire of public officials to keep paving and the kickbacks that contractors frequently are noted for giving. And this practice has been taken in this country as well, I would imagine. And it's not unusual that in foreign countries the decision to buy this aircraft would be made, even if they don't need it, because they know it's the quickest way that they can get a payback.
Quickest way to get rich. Here, I just want to read from a memo here to illustrate this point. That has to do, it's a memo from Mr. Cederberg to Mr. Crockett, and it's on payoffs or kickbacks or bribes that we've been discussing this morning. Were they reported prior to the investigation that led to this hearing? Were they reported to your board of directors?
No, the first time that these were reported to the whole board of directors was June 23rd of this year.
And that was after our Northrop hearings in this subcommittee, was it not?
I believe that's right.
That's part of the same pattern about which I've remarked before, that large American companies engaging in these practices refrain from advising the board of directors, which is usually the last to know. Rather like the Congress,
Chairman,
last to know.
referencing your picturesque language, I have just one question involving language used in pages 88, 89, 90, and 91. And I read right from the top of page 89, it's quite apparent that consultants, but the word locus is crossed out. Past and current performance in keeping sanitized, delete, expletive, or whatever, it's a name, deleted, happy, remains effective, remembering that blank is one of the key people we must satisfy with not only what we do, but also with how we do it, and etc. What was the code name locus used for, and why was this document sanitized to change it all throughout the document to the word consultants? Was that locus the code name that was used for your consultants before, and how did you happen to choose the word locus? What's the implication?
I don't know. You gentlemen know that the code
This
name.
memorandum was to Mr. Cowden. Maybe he could answer it.
Well, I think that the answer is yes, that is a code word for consultant, and they are selected by a computer, as a matter of fact.
The code words are selected by a computer?
By computer.
That's correct.
That's amazing.
It's amazing. I don't know if IBM is wrong then when they had this code word think. Maybe a computer can think, and it came up with the right word.
Even the computer had a conscience. Senator Biden?
Thank you very much, Mr. Chairman. I truly appreciate the opportunity to sit in on this hearing, although I'm not a member of this subcommittee.
Senator Biden, you not only have that opportunity, but I'm now going to turn the remainder of the hearing over to you as the ranking Democrat, because I have to leave at this point.
When the chairman said, we've got to search for a way out of this, I'm not sure I want to look with you for a way out, to be perfectly blunt about it. When you explained a little bit earlier about how, in fact, you thought this thing should be played, it reminded me of the rationale used over the last couple of years and the rationale used by some of our friends involved in politics. In short, if my opponent is stuffing the ballot box, then I better damn well stuff the ballot box. And that's the American way, and that's the way we got to do it. And if it interferes with what the laws say and what our concept of morality is supposed to be, well, that's just the price of doing business. I'm in business. I'm a politician. I'm in the business of getting elected. So I assume you'd condone my stuff in the ballot box because my competitor's stuff in the ballot box.
No, sir, I wouldn't condone
Well,
that.
I'd be curious to know why not. That's the most intriguing thing you've said all
Well,
day.
because in the first place, it's against the laws of the United States of America.
Well, that hadn't stopped you. It hadn't stopped you. For example, the tax structure.
I haven't stuffed any ballot boxes.
You've done a hell of a lot worse than stuff a ballot box, in my
I
opinion.
don't-
You may have corrupted the system completely to the point that you have people making gains in other countries and people who reflect your point of view that do more than we could ever do in our whole policy of containment with communism. You have a situation in Italy right now, as has been pointed out time and again. The Italians aren't embracing the Communist Party because of the fact the Communist Party represents a point of view that they reflect. They're embracing the Communist Party because the other parties have been shown to be so replete with corruption that, in fact, they got no place else to turn. Go on. I'm just really curious to what I'd like to hear what you didn't do. You told us what you did do. I'd like to find out whether or not you, in fact, think that there is any way. Well, maybe I should just drop this whole thing.
Well, I think our statement, Senator, I think our statement is clear on our position on this whole subject.
You know, it's one. Well, I guess that comes from lack of experience. Your statement is clear, and what you say confuses the clarity of your statement, in my mind, and I end up not knowing quite what you're saying. But I'll try to be very specific, and I'll be short. Number one, I can understand you're saying that you didn't that in order to compete for the interest of your company and in the interest of America, because we need exports. In order to compete, you in fact had to engage in practices that you may not have liked to do. And if anything, all you were doing was adding to the price of the aircraft and the cost of the aircraft. But then, when you talk about, and the ranking Republican didn't get a chance to didn't decide to go into it in very much detail, but the documents are replete with it. The question of how you handled these dealings in other countries vis-a-vis our tax structure. Domestically, our domestic tax structure, how you handled and decided to treat your dealings abroad, takes on a whole other question, it seems to me. If in fact you are violating the law, you are in fact directly cheating the American taxpayer. If in fact it is a violation of the law, because it means less tax revenue. Charlie, it's the only way we can compete. That's one thing. It's a completely separate issue when, in fact, you take that action you didn't want to engage in this country. I think that's an important distinction to be made, assuming
The United States, both from a personal standpoint and a corporation standpoint, that we're supposed to pay under the laws of the United States. And we are re-reviewing all of our tax submittals for several years. It will not affect the amount of payment in the near term because due to our severe losses, we haven't been paying taxes. But on the other hand, the tax reports must be correct and they must be complete, and we want to get them in that position if they're not already.
Okay, I'll try to ask short, specific questions. Number one, do you know whether or not, or do any of your representatives at the table know whether or not the Soviet Union, when they sell arms, they engage in the type of practice you do abroad?
I don't know. I don't know their sales practices, Senator. I just don't know.
Do either of your gentlemen know? Do you know? Do you know of the sales practices of any? You can't convince me that the guy you're kicking back to isn't saying to you or one of your agents at some point, hey, look, I'm getting 100,000 from you, but Harry over there, he's getting 175,000 from whomever else. You mean you guys didn't know that was going on?
Well, I don't think we know specifically, case by case, as to what the competition did or didn't do.
You knew enough to spend $100 million above the cost of the aircraft, though, didn't you?
What's that?
You knew enough to expend, you had enough information to warrant a business judgment.
That's not just on aircraft, that's on a lot of other things that where other countries and other companies could very well compete.
Yeah, but again, fellas, look, I wouldn't mind if you had none. Then, if you follow a logical line of reasoning and the little syllogism we're putting together here from a basic freshman logic course, if you had no idea, then your rationale for testifying before us today is non-existent.
Well, we said we had reason to believe, and
What reason? Give me specifics,
well,
please.
Well, a lot of times we don't win, we lose. You know,
Oh, I see. So you assume you lose because a dirty pool is not a better product.
We hear gossip, but we don't go on that basis as being absolutely a fact that we know. But
Well, you went on to the
you
point
can
of
read
spending
in-
millions of
you can
dollars.
read by smart reporters in the New York Times or the Washington Post or any place you want to that this is, in fact, a way of life overseas.
Did the reporters from the Times or the Post consult with you in 1962 to advise you of that fact?
No, they sure
Well,
didn't.
then why in the hell did you make the decision in 1962?
Well, because we were engaged in trying to compete in a foreign market, and we competed according to the customs and the ground rules that were in effect out in those foreign markets.
Okay, you've answered the question by not answering the question, and I want the record to be clear that you've done just that by skirting the response. In fact, long enough to adopt the proper senatorial protocol to say yes sir, no sir. You're not a company that in fact employs people in Delaware, and I don't have to reconsider what I said to you.
Senator Biden, I have a 12:30 appointment. I have a few
think
more.
I apologize if I have altered the decorum in a way which is not appropriate for this committee, but they're not getting straight answers.
Mr. Houghton.
No, you can't. Thank you.
Yes.
Mr. Houghton,
Now,
Chairman,
ma'am,
would
please
you call
sit
for
down.
order in the room?
Yes. Will there be order in the room? And if there is no order, will the police officer please remove the lady who stands up?
Mr. Houghton, I'd like to end my part of the questioning of you going back to.
I think we made our statement amply clear that
Okay, I just
we've
want
not
to
brought
know.
any money back into this country, laundered or through agents or otherwise, in our domestic political campaign.
Well, I didn't expect any other answer, and I have no basis for anything. But just like I asked that other question, I never expected the answer. I thought I'd just ask it for the record. And the last question, this promise this is the last one. Could you supply for the record the list of all your consultants around the world who happen to be former officers in the United States military? I'd be curious to have that.
Yes, we can submit that to the record.
Good. Well, unless you have any statements,
Yes, please. The largest arms exporter in the world has a special responsibility to try to eliminate such corrupt practices. Heard to date, not only with respect to this company, but to a number of other large American companies, that the bribes and the payoffs associated with doing business abroad represent a pattern of crookedness that would make, in terms of its scope and magnitude, crookedness in politics look like a Sunday school picnic by comparison. That ought to concern this country, the business community, and the government. Something has to be done about it. What was merely implicit in the Northrop documents released by the subcommittee in an earlier hearing is most explicit in the Lockheed documents. That is, that foreign agents and consultants are hired not for their local expertise or their technical knowledge, but for their connections in influential government circles, and they are paid huge fees, not for services rendered, but so that a part or most of these fees can be passed on as bribes or kickbacks to foreign officials. Indeed, in Indonesia, Lockheed did away with the fiction of a middleman altogether and paid its agents' fees directly to a group of Indonesian military officers. As it is the purpose of this inquiry to lay bare the facts without entailing the United States
a year-long study by the Secrecy and Disclosure Subcommittee of the Intelligence Committee. We have been concentrating on this first year upon the impact of secrecy on the enforcement of the law and the administration of justice. We have come to a surprising conclusion that the inevitable tension between the rule of law and the secrecy necessary for intelligence operations has at times, in my opinion, undermined both the rule of law and secrecy. These hearings will explore that phenomenon and hopefully will lead to a public discussion which will result in a better accommodation between law enforcement and secrecy. We examined will result in further necessary disclosures of the very sensitive information that will undermine the national security. Our concern over this problem deepened as we learned that the fear of disclosure of intelligence information could also frustrate investigation and prosecution of crimes less directly related to the national security, including perjury to Congress, narcotics violations, possible violations of intelligence community legislative charters, and even have affected, in one case, in our opinion, murder. The purpose of these hearings is to discuss this problem to the extent that it can be discussed publicly and to search for solutions. We will have difficulties, of course, in discussing this problem in a public hearing. We do not want to do further damage to the national security by disclosing exactly what we found in any one of the files we have reviewed. In practically every actual case we have reviewed, there were real national secrets at stake. There were real national secrets at stake, and at least a reasonable argument for foregoing indictment and trial. In order to provide focus for the hearings and to keep the discussion from becoming too amorphous, I've asked the subcommittee staff to prepare an unclassified staff memorandum, and I quote, on how to deal with the use of classified information necessary for investigation and prosecution in these cases. Briefly stated, There is no formal mechanism that we know of to weigh the risk of further disclosure against the benefits of prosecution. Common circumstance in leak cases is that the intelligence agency whose information is leaked also possesses the information and expertise necessary to investigate and prosecute the leak. In some cases we have reviewed, it appears that the victim agency and the Department of Justice in effect create an unnecessary dilemma or impasse in order to frustrate investigation or prosecution for other reasons, including prosecution of a leak through confirmation of the leak will damage the agency's reputation for keeping secrets and thereby undermine its ability to obtain confidential information from intelligence agencies both at home and abroad. Also, that the leak was from a high agency official who acted without higher authority, but the judgment is made that pursuit of the investigation would embarrass the official, or the leak is actually an authorized disclosure and pursuit of the investigation would be unjust. The unauthorized public disclosure of classified information which endangers national security are only a small portion of the intelligence product which is leaked routinely to the news media. Officials often make unauthorized disclosures of classified information in an attempt to influence public debate in a manner they believe to be in the national interest. In attempting to serve their view of the national interest, some damage to the sources and methods of intelligence collection may be inflicted. These leaks, in other words, are the mistakes that occur in the widespread sub-rosa practice of providing selected intelligence information to the news media. And these create serious problems. Some of the problems are because the process is informal and quasi-legal, there is no way to ensure that the public receives a balanced selection of intelligence information that is important to the public debate about defense and foreign policy. Second, the same hit-or-miss system that shortchanges the public on one end also results in occasional compromise of sensitive intelligence information. Insofar as the subcommittee staff could determine, most compromises were accidental byproducts of a disclosure made to accomplish some other purpose. Typically, a disclosure about Soviet plans for a new ICBM might accidentally compromise the source of that information. Now, disagreement over the use of classified information also impedes classical espionage prosecutions. However, the likelihood that there will be a consensus resolution of the disagreement is much more likely for the following reasons. Because classical espionage cases are generally considered more serious than leaked cases, and secondly, because the federal espionage statutes are more clearly drawn to cover classical espionage cases than leaked cases. Many classical espionage cases are in effect out of the control of the intelligence community because the law enforcement machinery has been engaged by an arrest or because public or officials outside the intelligence community know of the crime and therefore create pressure upon the intelligence community to provide information necessary for prosecution. Usually, the constitutional problems, that is primarily First Amendment problems, are much less severe in classical espionage cases than they are in leaked cases. However, we have reviewed classical espionage cases which have not proceeded to either investigation or prosecution for the same reason that leaked cases cannot proceed. Concern about the disclosure of intelligence information in the course of investigation and prosecution being the reason. Furthermore, we know of cases where the disagreement between the intelligence community and the Department of Justice over classical espionage cases almost required presidential intervention to resolve the disagreement. The impasse over the use of classified information occurs in other types of criminal cases, and at times the Department of Justice may have been placed at a marked disadvantage because of this dilemma by defendants in perjury, narcotics, and even murder cases. Before turning to Senator Pearson, I would like
decision whenever intelligence interests are concerned. On the contrary, I think I have a necessary role. In the first place, I consider it my responsibility to ensure that no relevant information is withheld from the Attorney General. That is, that he has access to all information without regard to classification that may be fairly thought to bear on the issue of whether a crime may have been committed and under what circumstances it may have been committed. I want to stress this aspect of the subject so as to avoid any possible misunderstanding. Access to relevant information should not be a point of dispute, because the Attorney General has a clear right and need to review all such information so that his decisions may be taken with the fullest factual perspective. Second, I see it as my responsibility to make known to the Attorney General my estimate of the importance of the intelligence information that may be identified as relevant to a criminal prosecution and the potential impacts of the public disclosure of that information. Again, I think that this kind of estimate is something that the Attorney General must have before him if he is to make informed decisions and properly weigh the consequences of those decisions. If I were to conclude in some particular context that the Attorney General had struck an incorrect balance, my recourse would be to approach the President so that he could determine as appropriate whether the net best interest of the United States favored prosecution, and so that he would at least be aware of my forecast as to the likely consequences of that course of action. Similarly, with respect to the declassification of documents said by the Attorney Cooperation, I'm sure that Mr. Civiletti will give his own appraisal on this score later, but I would like to give you my own appreciation, which is that the relations between the CIA and the Department of Justice are not at all strained or hostile, and indeed are marked by mutual good faith and shared understandings about the dilemmas I am now discussing. Certainly it is true that there is a continuing dialogue and debate, and sometimes adversary exchanges, but that is hardly surprising in the light of the divergent interests being represented. Usually there is an accommodation, but where there is disagreement, it stems not from poor relations, but rather from the intrinsic difficulty of the issues we confront. Let me turn now to some more fundamental reasons with which we have to work. A criminal trial in this country is a public event, and there are constitutional guarantees that make it so. I have no quarrel with those guarantees, but at the same time I cannot ignore the extent to which they contribute to the problem when it comes to making evidentiary use of intelligence information. When an election is made to use such information, it is on its way to the public domain, and there are few, if any, ways to avoid that outcome or to limit the exposure of the information to the actual participants in the trial. Other constitutional provisions secure an accused broad rights of cross-examination, and the applicable rules of procedure confer on the accused rights of wide-ranging pretrial discovery, to look behind the prosecution's case and to develop his own defenses. There are not many legal tools available to regulate and control this flow of events, just because the information in question happens to be sensitive from a national security standpoint. In addition, these same features, which make the judicial process almost as uncertain as it is open. For example, the lines of defense which will be followed, and the scope of discovery and cross-examination which will be allowed, are not matters that lend themselves to precise, advanced measurement. They are heavily unpredictable, and what that means is that the decision to prosecute is that much more difficult for those who must gauge as best they can before the course is set where it all might lead. Again, I am not complaining about any of this or suggesting any radical reforms that would strip away the rights of the accused, all of which exist to assure fairness of criminal proceedings. I'm only trying to describe how things look from where I sit and to put into their true settings the hard choices that have to be made to intelligence agencies. Let us suppose, if I can make a hypothetical case also, Mr. Chairman, that a former government employee were to be arrested in the course of delivering a CIA document to a foreign agent, and that the arrest prevented the delivery from being completed. And let us further suppose that the document summarized current agency operations in another country and included a roster of CIA officers in that country. A crime under the espionage law certainly would have been committed, and that crime must certainly rank high in terms of compelling governmental interests in prosecution. Yet such prosecution would exact an extraordinary price. As I understand it, the government would be required to show that the information in the document was of enough significance to materially injure the national security had it fallen into the hands of the foreign agent. Now, that burden of proof would almost surely require that the document itself be offered in evidence, that its accuracy be confirmed by a knowledgeable agency witness, and that its value be explained. In result, the trial proceedings would have succeeded in doing just what the defendant himself was being tried for having attempted but failed to do. That is, to transmit the disclosed information. And the accuracy of that information would have been verified in the bargain. I am sure you would agree that a spectacle of that sort would not be pleasant to contemplate for those who had to struggle with a decision to prosecute. For almost every system, if enough detail about it is disclosed. In releasing information which is essential to such judicial proceedings. Beyond that, however, we in the intelligence community feel that the country desperately needs to prosecute these offenders in the name of deterring others. In the brief year that I have been part of our intelligence organization, we have held our breath while releasing data to permit the prosecution of 3 espionage cases. I assure you that the incentive to release information for the purposes of prosecution of secrets we will degenerate into chaos in this vital zone of national defense. Thank you, sir.
Very much, Admiral. I'd like to legitimate reasons. The exposure to these cases, there have been some serious national security leaks. These aren't just little things. Some of them are of some consequence that, in your judgment, and I'm using you in an editorial sense, the judgment of the agencies, the judgment of the Justice Department, it hasn't, they have not lent themselves under our criminal process to prosecution. So we're really here.
Justice and the intelligence agencies have grappled with this issue satisfactorily at times, and I think unsatisfactorily at other times. The problems are presented not only in connection with espionage prosecutions, and I think it's safe to say that in our free and open society, which we all treasure, we are from time to time victims of such efforts in the modern world by hostile countries in even increasing ways and efforts, so that the vigilance which we utilize must be maintained, and the efforts which we make to apprehend and prosecute where the criminal laws have been violated are extremely important to all the safety and security of the citizens of this country and our system. We have been fairly successful with regard to many espionage prosecutions. The second area concerns perhaps not direct espionage, but it concerns the subject which you so correctly were addressing to Admiral Turner, and that is the problem of leaks or the disclosure of confidential or classified information in one manner or another. We are, frankly, under our present system, far less successful in that area in prosecutions or in even determining with precision the source of such leaks. Partly that's due to evidentiary problems generally with the leak situation. Partly it's due to our firm and everyone's firm belief in the tenets of the First Amendment. And partly it's due to the fact of life that with a great deal of classified information, government, that is the government, the intelligence community, or the National Security Council, must, to perform its duty, disseminate that information to a wide variety of people in a classified form. That makes the evidentiary trail a difficult trail to follow, and one in which you may point the finger of guilt at a particular group or particular department, but the criminal law, of course, requires evidence of individual guilt beyond a reasonable doubt, or at least a fair chance to establish that in a court of law, and that becomes a much more difficult proposition. The third area in which this subcommittee is addressing, and the balance between disclosure and protection, is the area dealing with other crimes, not espionage or leaks, but other crimes which are associated with intelligence actions or activities. Either the rogue elephant circumstance, which is, I believe, rare today, extremely rare, or the circumstance of people associated with or even incidentally related to intelligence activities who commit unrelated crimes such as bribery or such as felonies or crimes against the person. And regardless who violates it, and we take the advocate's position, not irresponsibly, that to the extent possible it is our duty to find a way to get the facts and the evidence and to prosecute. We are sensitive to the somewhat differing responsibility and philosophy of the intelligence community who do not have direct law enforcement responsibility, but do have the terrible burden of protecting the security of the country, its processes, and its secrets, so that we do not blindly override their concerns, and we try to understand them, and through a escalating process from time to time, those differences in philosophy as well as in missions are attempted to be resolved first between the line attorney, who is the prosecutor, or the investigators, and the lower level employees. Three areas that I mentioned, and our attempts to resolve them are imperfect. They need sound thinking, they need attention, and they need discussion, as well as the guidance and expertise of those in the Congress and in the community at large who provide a different point of view, an additional point of view to those of us in justice and in the intelligence communities who address these problems regularly and have thoughts and efforts to resolve the difficulties and try to draw the lines in these areas to the best of our ability. So that I am happy to be here. I am glad that the hearings are being conducted in such a responsible way and probing into an area of great difficulty which requires attention, sound thinking, and hopefully progressive resolution.
Thank you, Mr. Saletti. I understand.
Until fairly recently, the problem was most apparent in espionage cases, either classical espionage cases or cases involving leaks of information. Such cases usually start when, in accordance with their statutory and/or regulatory responsibilities, agencies advise us that national security information has been or is about to be disclosed improperly. Upon receiving such a report, or prior to the time an arrest or other action is taken in those cases, in which we have indications of an ongoing or anticipated act involving the compromise of national security information, we initiate discussions with officials of the agency involved to determine what action can and should be taken. One area we must focus on is one which has troubled us for many years: how to maintain the prosecution and at the same time protect the national security information involved. This problem inevitably arises, for defendants, of course, are entitled under the Constitution to a public trial, and the evidence used against them must be made public. In practical terms, this means that if we are to attempt to prosecute someone for releasing national security information improperly, we must be prepared to disclose at least a part of the information publicly. While that may not seem to be much of a problem initially, if the information has already been leaked or given to a foreign government, what is the harm in making it public? It is often, of course, very serious. For example, even assuming the information has already been leaked and or has already reached a foreign power, our reliance on it at a public trial will necessarily confirm the accuracy of the information. This is a considerable benefit, for while foreign powers receive a steady flow of information from a variety of sources, they must always grapple with the initial task of separating the wheat from the chaff, culling out from the mass that which is accurate. A public trial must of necessity help them accomplish that goal. This problem can be compounded if we capture the foreign agent or the individual or individuals willing to compromise national security information and prevent the actual disclosure of military or state secrets. Under those circumstances, the damage which occurs in cases where we cannot retrieve the information before it is made public or sent abroad has obviously been avoided. Disclosure of the information involved in a public trial, then, would not only confirm its accuracy, but it would also accomplish the very thing we try to prevent: its compromise and the transmittal of such information to a foreign power. The first decision we must always make, then, is whether the game is worth the candle. Is the prosecution more important than the potential harm we may cause to the nation's security's interest? When we first meet with the agencies, we make it clear
As a possible means by which we could diminish the problem we all acknowledge exists is an in-camera procedure for judicial supervision of the use of classified information. Congress might enact an in-camera procedure for judicial supervision of the use of classified information in the course of civil and criminal proceedings in which the U.S. is a party. The procedure might be modeled after Section 509 of the Rules of Evidence proposed by the Supreme Court in 1974. Section 509 defined, quote, a secret of state, end of quote, privilege, which might be invoked by the government, which would in turn promote an in-camera adversary proceeding in which the parties would litigate the use of the information usually classified, to which the government had invoked the privilege. Now, to make this even clearer, it refers to either the witness that you say is sometimes troublesome, that need not be produced, and or specific documentation, information that is classified in order, that must be introduced in evidence under ordinary circumstances to bring your case to successful conclusion. Section 509 was rejected by the Congress as it reviewed the rules proposed by the Supreme Court. However, any proposal made at this time might respond to the criticisms of Section 509. For example, the new state secret privilege,
I think you've already touched on that in posing the question to me. One, of course, is those in which the information, the classification and status of the information is part of the substantive offense that's involved. The classic espionage situation, even the leak situation, where part of the element of the proof is in fact that the information was properly classified or did in fact relate to the national defense. That we feel is definitely a jury question. We feel that the waiver possibility of the waiver of a jury raises serious constitutional questions because of the interest in a public trial. Now, if we, however, go to the easier part of the question, that is those matters that are preliminary to the presentation of our evidence in chief, I would first like to point out that a great deal of material and a great deal of procedures are attempted to now proceed in camera. For example, Rule 16 of the Federal Rules of Criminal Procedure, which provides access to state
changes in criminal or administrative procedure that we in the Congress could initiate in order to aid you in what is obviously a serious dilemma.
I think in the substantive elements of the defense center, I quite agree with you that the espionage statutes need some reform, and the language of 1917 and 22 is not totally applicable today. Though an interesting sidelight is when we tried to redraft those statutes for the, I'm not even sure I want to mention the bill number and further weaken my credibility, but for the first draft, or one of the first drafts of the Uniform Code, the Uniform Criminal Code, we struggled with redefining information related to the national defense, and after a 6 or 7 month struggle, finally came up deciding to use the litigated history that we had and using the same terminology. So I'm not entirely certain we can totally modernize those statutes. I think they can be made much more easy to understand and perhaps more attuned to the problems. But I don't think it will change our problems because you would still have to, I think, in the classic espionage situation, have to establish the elements of the offense in the trial, and that part of that element would have to be the character of the information that was compromised. We do have certain statutes on the books, of course. So I believe you referred to them in your opening, one of them in your opening statement, 18 U.S.C. 798 and 50 U.S.C. 785 or 783B, I believe, which in different ways are somewhat restricted, but they apply only to the compromise or misuse of classified information. And we do not have the same burdens in the public trial of proving that the information wasn't related to the national defense. There isn't the same testimony back and forth about a great mass of material related to a particular document or documents. We have had one prosecution under the latter statute, which I'm sure your staff is aware of, the United States versus Scarbeck, which was a
Very troublesome matter. Tomorrow our witness was Lockheed Corporation. The hearing is recessed until 10 o'clock tomorrow morning. Summary of findings. Our inquiry into over 40 actual cases has led the staff to the following conclusions. A, there is a major breakdown in the administration of criminal espionage statutes in leak cases. To date, we have been unable to identify a single successful prosecution of an individual who leaked classified information to a publication. This record was found despite nearly unanimous assessment that at least some leaks cause serious harm to the national security. The breakdown results in part from an impasse between the Department of Justice and the intelligence community.
At the same time, Mr. Chairman, I would urge you to recognize that the seriousness of these losses through unauthorized disclosures gives us in our intelligence community great cause to support the prosecution of individuals who do the disclosing. My blood boils at the obvious callousness and selfishness of such persons, and I believe that they more than deserve the punishment which might result from prosecution. This alone is incentive for us to lean over backwards, are indeed strong. I would also and finally like to add my strong dissent with a sometimes popular view that in fact encourages individuals to break our laws in the name of whistleblowing on what they think are individuals they perceive to have performed improperly. I do not question that such whistleblowing has served our national purposes in a few instances in the past and may again in the future. I would point out, however, that the Congress, in its wisdom over the past 2 years, has created an alternative to public whistleblowing on intelligence services. This is a select committee on intelligence in each chamber of the Congress. Never have I seen these committees deny a citizen's request to report on what he believes to be malperformance. In addition, the executive branch has created a corresponding safety valve in the Intelligence Oversight Board, a body totally independent of the intelligence community and reporting directly to the President. Thus, with such a body in both of these branches of our government, a citizen has recourse even if he suspects collusion at high levels of one or the other. I would submit that I have yet to see one of these so-called whistleblowers who directed his whistle first at one of these authorized mechanisms. This leads me to suspect that rather than being patriotic heroes, as some are wont to describe them, these individuals are more likely to be self-serving charlatans in quest of fame or fortune. In short, it is my view that we have the mechanisms for to pass upon our national...
Every December, January, and February in this town, we're treated to the same old business. The Russians are coming, the Russians are coming. Not only are they coming, they're 30 feet tall. Now, that's not accidental. We all give it a kind of a wink and a nod because we've been around long enough. We begin to see it after a while. There's a pattern to it. Unfortunately, people out in the country take it seriously, and I take it that's the purpose of those kinds of disclosures, to justify greater budget expenditures. Now, if people are elected to vote on those things and given committee assignments to examine budget requests, and the Pentagon can't convince them of their needs, but rather have to go in an unauthorized, highly selective, highly prejudicial disclosure or leak route to get to our constituents to frighten them so they'll frighten us, then I think something ought to be done about it. That's what the leak problem is.
I agree with you fully.
But there's such hypocrisy about this whole Pentagon operation, it just makes me sore. I think it's cynical as hell, and it shouldn't be the way we run this government.
Well,
and you know, what are if the chiefs are not obeying the law, why should the Indians? I mean, it's a direct incentive to every government employee in the government to tell anything they know because they just saw some assistant secretary or secretary of defense or high-ranking general or admiral call in the AP or some favored reporter who's been reporting on defense matters for years and tell them everything we know, or almost everything we know, about what the Soviets have been up to.
I'm not...
I'm sorry, I drove down from Delaware.
Morning. Good to see you.
The hearing will come to order, please. I'd like to begin by apologizing for being... These hearings culminate... Not just wait. I said not just wait. I apologize. Hypothetical case you gave is a very, very poignant case. That how in the Lord's name do you, as a director, suggest that that person be... Point out that in most
Implications of that procedure at this time.
Senator,
Is that the impression of your statement that
yes.
you wish to convey? In matters of leaks, successful.
You. Appreciate your testimony. I notice Mr. Civiletti has walked in the room. He is our next witness. Mr. Civiletti, there are 5 buzzers up there, which means there's a vote on. It'll take us about 8 minutes to get over and vote and be back. Is it convenient for you to begin testifying at approximately 5 after 12?
Yes.